So what is the Artificial Intelligence Act? The EU regulation 2024-1689 from the 13th of June 2024 is what is called the AI Act, the Artificial Intelligence Act. It is from the EU and it provides a comprehensive sector-agnostic regulatory regime which forms the foundation of artificial intelligence, AI, governance and regulation across the EU, with downstream implications for companies and developing legislation around the world. The AI Act is part of a package of new EU rules focused on achieving Europe's digital targets for 2030 and the digital ecosystem shaping Europe's digital future, along with the Digital Markets Act, the Digital Services Act, as well as the Data Act and the Data Governance Act, which form a single set of rules that apply across the EU to implement the two following goals: create a safer digital space in which the fundamental rights of all users of digital services are protected by setting clear and proportionate rules, and establish a level playing field to foster innovation, growth, and competitiveness, both in the European single market and globally. So we previously released 2 articles and proprietary research content, both via podcast and articles, on the Digital Markets Act and the Digital Services Act. So we refer you to our 2 websites, crefovi.com and our French language website, crefovi.fr, in order to double check, if you wish to do so, our previously released content on the Digital Markets Act and the Digital Services Act. You can also listen to our podcasts episodes on these 2 additional EU acts. More specifically, spanning 180 recitals and 113 articles, the AI Act is a tiered, risk-based approach to regulating the entire life cycle of different types of AI systems, with the following consequences. AI systems for certain uses will be prohibited. Certain AI systems will be designated as high-risk AI systems and subject to extensive obligations, especially for AI providers. There are some specific provisions governing general-purpose AI models, GPAI models, where those GPAI models are regulated regardless of use case, and other AI systems are considered low risk and therefore are subject only to limited transparency obligations when they interact with individuals. The AI Act is a result of extensive negotiation aimed at laying down a harmonized legal framework for the development, the placing on the market, the putting into service, and the use of artificial intelligence systems in the EU. So when does the AI Act enter into force? Well, it was published in the official journal of the EU on the 12th of July 2024, more than 3 years after the proposed original text was released by the EU Commission in April 2021. On the 1st of August this year, in 2024, the AI Act entered into force. Now that the AI Act has been published, its requirements will take effect on a rolling basis over the next several years as follows. By the 2nd of February 2025, companies and businesses must stop all use and operation of AI systems that present unacceptable risk. By the 2nd of August 2025, companies and businesses must ensure that all transparency requirements and obligations relating to any use of the general purpose AI models are met. By the 2nd of August 2026, companies and businesses must ensure that all operational procedures for high-risk AI systems are met and in place for existing and future AI systems. By the 2nd of August 2027, companies and businesses must ensure all provided and deployed AI systems comply with sector-specific AI regulations and standards in existence within the EU. And by the 2nd of August 2030, the grace period for high-risk AI systems intended for use by public authorities ends. For example, organizations will have 6 months to ensure they do not use any AI systems or technologies that may pose unacceptable risk. Similarly, many organizations will have 24 months to ensure they have the operational requirements in place to develop, provide, and or deploy high-risk AI systems in a compliant manner, subject to certain exemptions, which we will mention in a second. As notable from the above-mentioned implementation timeline, most provisions in the AI Act will apply after a 2-year implementation period, i.e. from the 2nd of August 2026. During this period, various supporting delegated legislation, guidance, and harmonized standards developed by the European standardization organizations will be published to assist with the AI Act compliance. Who is affected and or impacted by the AI Act? AI systems. What are AI systems? Well, most of the obligations under the AI Act concern AI systems, which are broadly defined as machine-based systems that are designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infer from the input they receive how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Verbatim, this is the definition of AI systems set out in the AI Act. What a mouthful. The AI Act establishes obligations for providers, deployers, importers, distributors, and product manufacturers of AI systems with a link to the EU market. So, for example, the AI Act applies to providers which place on the EU market or put into service AI systems or place on the EU market general-purpose AI models. The AI Act also applies to deployers of AI systems who have a place of establishment and or are located in the EU. And this Act also applies to providers and deployers of AI systems in third countries if the output produced by the AI system is being used in the EU. The AI Act also enumerates certain exceptions to its material scope. For example, the AI Act does not apply to open source AI systems unless they are prohibited or classified as high-risk AI systems or AI systems used for the sole purpose of scientific research and development. EU member states are able to maintain or introduce national regulations that are more favorable to workers in terms of protecting their employment rights in respect of the use of AI systems by employers, or encouraging or allowing the application of worker-friendly collective agreements. What are prohibited AI systems? The AI Act bans certain AI practices across the EU, which it considers harmful, abusive, and in contradiction with EU values. The prohibited AI practices include the deployment of subliminal AI techniques beyond a person's consciousness or purposefully manipulative or deceptive techniques with the objective or the effect of materially distorting human behavior. AI systems for biometric categorization and identification, including those for untargeted scraping of facial data from the internet. Another prohibited AI practice relates to AI systems for emotion recognition in law enforcement, border management, the workplace, and education, and AI systems for the social scoring, evaluation, or classification of natural persons or groups thereof over a period of time based on their social behavior are also prohibited. The AI Act carves out a few exceptions, though, to this rule for law enforcement purposes relating to the use of real-time remote biometric identification in publicly accessible spaces. What are high-risk AI systems? The most onerous regulatory obligations under the AI Act attach to high-risk AI systems, with the aim of implementing a proportionate and effective set of rules for AI systems. The AI Act establishes a high-risk-based approach to regulation and categorizes AI systems based on the intensity and scope of the risks each AI system can generate. High-risk AI systems, which are AI systems that present a high risk, fall within the two following categories. AI systems used as a safety component of a product or otherwise subject to EU health and safety harmonization legislation, as well as AI systems deployed in 8 specific areas, including biometrics, critical infrastructure such as water, gas, and electricity supplies, education, employment, access to essential public and private services, law enforcement, migration, the administration of justice, and the insurance and banking sectors. An AI system deployed in these 8 specific areas is always considered high risk if it performs profiling of natural persons. As a derogation, an AI system that falls within those 8 specific areas may be deemed as not posing such a high risk if its intended use is limited to performing narrow procedural tasks, making improvements to the results of previously completed human activities, detecting decision-making patterns or deviations from prior decision-making patterns without replacing or influencing human assessment, or mere preparatory tasks to a risk assessment. The AI Act imposes a wide range of obligations on the various actors in the life cycle of a high-risk AI system, which include requirements on data training and data governance, technical documentation, record keeping, technical robustness, transparency, human oversight, and accuracy, robustness, and cybersecurity. For example, high-risk AI systems which make use of techniques involving the training of models with data will have to be developed on the basis of training, validation, and testing data sets that meet the quality criteria set by Article 10 of the AI Act. High-risk AI systems providers will also be subject to various procedural obligations before they supply any high-risk AI systems. The providers must ensure that high-risk AI systems undergo a conformity assessment procedure before the high-risk AI system is supplied and affix a CE, C for Charlie, E for Echo, conform with a European mark to its documentation. Also, the procedural obligation relating to high-risk AI system relates to the registration in the EU database. The providers and public bodies using high-risk AI system must register this AI system in an EU-wide database of AI systems. And also there are some reporting obligations. High-risk AI system providers must report serious incidents or malfunctioning involving the high-risk AI system to a relevant authority within 15 days. Other operators of high-risk AI systems will be subject to more limited obligations, such as to complete fundamental rights impact assessments, ensure they use the high-risk AI system in accordance with its instructions of use, monitor the operation of the high-risk AI system, and keep a record of the logs generated by the high-risk AI system, if under their control. Article 7 of the AI Act also provides for a process and some criteria for the addition of new or the modification of existing use cases for high-risk AI system by the Commission. So high-risk AI systems are subject to extensive obligations, especially for providers. What are the specific provisions governing general-purpose AI models now? General-purpose AI models are AI technologies which are not prohibited or high risk, and they will be subject to much less onerous regulatory requirements, therefore. The most onerous other requirements under the AI Act attach to general-purpose AI. The requirements for most general-purpose AI models, which include foundation models and generative AI models, are chiefly focused on transparency. A general-purpose AI model is defined as an AI model, including where such an AI model is trained with a large amount of data using self-supervision at scale that displays significant generality and is capable of competently performing a wide range of distinct tasks, regardless of the way the model is placed on the market, and that can be integrated into a variety of downstream systems or applications, except AI models that are used for research, development, or prototyping activities before they are placed on the market. This definition is vague and leaves room for interpretation to competent regulators, national legislators, and courts, in particular what significant generality means. The AI Act will not apply to any AI systems or models, including general-purpose AI models and their outputs, where they are specifically developed and put into service for the sole purpose of scientific research and development. The classification of general-purpose AI models with systemic risk is addressed in Article 51 of the AI Act. A general-purpose AI model is classified as a GPA model with systemic risk if it has high-impact capabilities, evaluated on the basis of appropriate technical tools and methodologies, including indicators and benchmarks, or is identified as such by the Commission. For example, a general-purpose AI model is presumed to have high-impact capabilities if the amount of computational power measured in floating-point operations is greater than 10. Floating-point operations, or also called FLOPs. The provider of a general-purpose AI model must notify the EU Commission if they become aware that a GPAI, a general-purpose AI model, does or will classify as one with systemic risk without delay, and in any event within 2 weeks. A list of AI models with systemic risk will be published and frequently updated by the Commission, without prejudice to the need to observe and protect intellectual property rights and confidential commercial information or business secrets in accordance with EU and/or member state law. All providers of general-purpose AI models are subject to certain obligations, such as making available and maintaining up-to-date technical documentation, including its training and testing process, or providing information to AI system providers who intend to use the general-purpose AI model, cooperating with the Commission and national competent authorities, and complying with national laws on copyright and related rights. Providers of general-purpose AI models with systemic risk have additional obligations, including the obligations to perform standardized model evaluations, assess and mitigate systemic risks, track and report incidents, and ensure cybersecurity protection. What about other AI systems? Save for the previously mentioned, and where two specific exemptions apply, military or defense, research and innovation, the only binding requirements for other AI systems is a limited obligation of transparency. Providers must ensure that AI systems that are intended to interact with individuals are designed and developed in such a way that individual users are aware that they are interacting with an AI system. There is, however, a general obligation on all deployers and providers of AI systems to ensure that their staff that deal with the operation and use of AI systems have sufficient AI literacy. The appropriate level of AI literacy depends on the education, expertise, and technical knowledge of staff, as well as the context in which the relevant AI systems are to be used. So what are the penalties and sanctions which apply in case a naughty person or organization is not complying with the AI Act? Organizations must consider whether they are subject to the AI Act, and if so, how they intend to comply with their obligations. If an organization fails to implement the changes dictated by the AI Act or disregards their obligations, and once the AI Act is fully enforced, they may be subject to heavy penalties for non-compliance, such as fines up to 30 million euros or 7% of global annual turnover of a preceding financial year, whichever is higher, for failure to comply with obligations relating to prohibited AI systems. Fines up to 15 million euros or 3% of global annual turnover of the preceding financial year, whichever is higher, for failure to comply with obligations relating to general purpose AI or high-risk AI systems, and fines up to 7.5 million euros or 1% of global annual turnover of a preceding financial year, whichever is higher, for supplying incorrect, incomplete, or misleading information to governing bodies and or authorities in response to their requests. For small, medium enterprises and startups, the fines for all the above are subject to the same maximum percentages or amounts, but whichever is lower. Article 85 to 87 of the AI Act also provide for the rights of natural and legal persons to lodge a complaint with a market surveillance authority to obtain explanation of individual decision-making and to report instances of non-compliance. To conclude, the AI Act is a way to promote innovation, but with an enormous amount of caution. Though the AI Act is primarily focused on governing organizations and individuals within the borders of the EU, it has broad international reach. Organizations far outside Europe, such as those operating within the US or Asia, may be subject to the AI Act requirements, even when they have no presence within an EU member state. So beyond its international reach, the EU's approach to the regulation of AI is increasingly appearing to be the standard for governments and regulators across the world. For example, the states of Colorado and California in the US and other international jurisdictions such as Canada have openly stated that they are aiming to map their approaches to their EU peers, while the AI Act openly says that it approaches AI regulation with a primary focus on preventing harm to the health, safety, and fundamental rights of individuals within the EU. It covertly stifles creativity, innovation, and risk-taking. Consequently, no AI company and or system will originate from the EU, and as such rules imposed by the AI Act all successful AI systems will come from the US and Asia, where regulations will be much weaker, if inexistent. Maybe all EU citizens will feel comfy and well protected by their nanny state. But meanwhile, the US and China will battle it out to win this current war on AI world domination. Sometimes only by getting out of your comfort zone and risking it can you make some substantial evolution and growth leaps. The EU has not taken this approach. I do not want to hear any whining and complaints in 5 years' time when the US and Asia will be so far ahead of Europeans that their technical advancements attract all the wealth, progress, creativity, and economic opportunities. Thank you so much, everyone, for listening to our podcast on the EU AI Act, and we shall see you soon on another episode of our Lawfully Creative podcast. Bye for now.